Welcome to Ask a Lawyer with the attorneys at Hepworth Holzer, life-changing law in Boise, Idaho. Today, it's Charles Hepworth. Charlie is universally recognized by fellow lawyers and clients as the leading Boise trial lawyer. No attorney in Idaho comes close to him for a record of success with medical malpractice cases. Charlie answers your questions about the law and how it affects you.
Charlie, what are medical devices?
So medical devices refer to components or foreign objects that are placed in the body for some purpose. It could include, if someone needs a knee replacement, it would be the components that are used for the purpose of the knee replacement. And if it's a hip replacement, it's the metallic components that are part of the hip replacement. It can be a screw or a plate that is necessary to treat a fracture, so it can be a number of different things, but that's what I think of when I think of a medical device.
Okay, so let's say one breaks. Can I sue for that, and who do I sue?
Yeah, so those cases again are complex cases. It's not all that unusual for some type of device that has been placed during a surgery to fracture. And the mere fact that the device has fractured does not necessarily mean that the individual has a valid case. So I have recently handled several hip replacement product defect cases. In a few of those cases, one of the components that is part of the hip replacement has actually fractured. So in those cases, we have taken the position that the fracture would not have occurred absent the component being defective. The simple fact that the component has fractured tells me as an attorney that that's significant. It's caused a significant problem for the patient. It results in the need for a surgery, and so it's a big deal for the patient from that perspective. But the fracture of the component itself is strong evidence that there was a failure of the product, and that probably there is a claim that I can help that individual with in that circumstance. I'd say a different example where I usually have not been able to offer assistance is that with spine surgery, it's not uncommon for a screw to break over time or a plate to become dislodged from its original location. And the feedback I've received as I have interacted with physicians on those types of cases is that, unfortunately, those problems can develop over time. And so the fracturing of a screw or the migration of a plate, does not necessarily mean that the doctor did anything wrong. So in order to have a valid claim, you have to prove that there was some defect with the product itself that caused it to fail. And sometimes you can prove that and other times not.
What if there's an FDA recall? Does that help with the claim?
Yeah, I think that does help. I think that tells you that the manufacturer has had enough episodes of failures of their product that they've decided to recall their product. Again, it's important to recognize that the mere fact that the manufacturer has recalled their product is not dispositive of the idea that the product is defective. The manufacturer may well recall a product, but also defend any litigation by saying that they recalled their product because they were getting a few reports of problems, but that they still maintain that their product was effective and appropriate and that it was not defective and that they did not do anything wrong with respect to the production of that component.
Well, let's say a person does have, grounds for a suit. Do you sue for damages? Do you sue for pain and suffering? What do you sue for?
Yeah, so the damages you can claim vary with the case. I'd say the most common damages you would claim would be the medical expenses related to the problem. So if there's a defective product that has to be removed and replaced, there will be a surgery associated with that. If it's a medical error that leads to follow-up medical care that's required, all the expense associated with that follow-up medical care or any care related to the medical error would be the type of damage that would be included. That's not the only damage you can claim, but so just to summarize, medical expenses related to the problem are recoverable, both those medical expenses incurred from the date of the problem up till the time of trial, as well as those medical expenses that are reasonably foreseeable in the future. So medical expenses is one category of damages. All personal injury cases and all medical malpractice cases involve claims for pain and suffering damages. Those damages somewhat define themselves. I'd say in this day and age, the most important thing to know about pain and suffering damages is that most states, and Idaho is one of the states, but most states have a cap or a limit on how much you can recover for pain and suffering types of damages. So medical expenses, which are what we call economic damages, in Idaho, you can recover all of the economic damages that you can prove. But pain and suffering damages, which we also refer to as non-economic damages, Idaho limits the amount you can recover to $350,000. So you can go to trial and tell the jury your story, and the jury might be so impressed that they award you $1 million in pain and suffering damages, given the severity of the injury. But because Idaho has a cap that the legislature has adopted that applies to non-economic damages or pain and suffering damages, even though a jury might award $1 million for those types of damages, you're limited to what the cap allows. And in Idaho, that's only $350,000. So that's the maximum you can recover. So medical expenses, pain and suffering types of damages or non-economic damages are damages that we often or almost always are making claims for. In some cases, an individual is displaced from work. And so we would also claim in those cases loss of earnings. Either if they've had a temporary displacement from their regular job, we would claim those loss of earnings. If, however, it's been a more serious injury and they are not able to return to that type of work, then we will make a more substantial claim for loss of earnings that goes well into the futures, that says, okay, this person used to work in one capacity. Because of their injury, they're not able to return to working in that capacity, and now they're able to only make a much reduced wage earning whatever they're able to do, and therefore they have a loss of earning capacity, and that can be quite substantial depending on the case and dependent on the demonstrated earnings of that individual prior to their injury. So those are the three categories of types of damages that we typically claim in a personal injury or medical malpractice case.
Can a person afford to contact an attorney?
Sure. Again, kind of the same answer I gave earlier, and that is we don't charge for initial consultations, and therefore I speak to people every day who are asking me questions about their situations, and I do my best to answer their questions and spend whatever time I need for that person to understand their situation. And I don't charge anything for the time I spend. It's just part of the process where that's how I identify cases that I am able to help with. And so for those that I'm not able to help with, there's no charge for the time it takes.
Thanks for listening to Ask a Lawyer with the attorneys at Hepworth Holzer, life-changing law in Boise, Idaho. Join us next time as they answer your questions about the law and how it affects you. They can be reached at 208-343-7510 or hepworthholzer.com.